Well, hello, everyone, and welcome to our panel. This is called The Why Are You Here of Legal Writing and Rhetoric. My name is Lisa Klotz. I am a lecturer at the University of California, Davis, where I teach in the university writing program. I mainly teach legal writing to undergrads. I have also taught legal writing at the law school level at the University of California, Davis School of Law, and also at the University of North Carolina School of Law. And I currently am also an adjunct faculty at the Mitchell-Hamlin School of Law in their blended learning program. I'd like to reintroduce you to our panel members. If you all could just state your name once again.
Hi, I'm Antonio Elefano. I teach undergraduate legal writing at the University of Southern California.
My name is Lindsay Head. I am an assistant professor of legal writing at St. Thomas University College of Law.
And my name is Brian Larson. I'm an associate professor at Texas A&M's School of Law, and I teach legal writing and jurisprudence or legal philosophy.
Okay, great. Thank you. So I thought we'd start us off with a couple of questions. And the first one has to do with Lindsay and Antonio's presentations. I was wondering if the goals of labor-based grading align with Antonio's observations about his workshop process. Do you see similarities and differences between those two techniques?
Go ahead, Antonio. I'll let you start if you want.
Sure. You know what? At USC right now, they have been piloting grading contracts for freshman composition, and now they're also piloting it for the upper level classes as well. And what we're finding is that it's quite popular with students, especially at the freshman level, but even at the upper levels. What people say is that it allows them to really focus on getting better as writers and on and less on obviously lawyering about the grades. I will say I just had a meeting with about this yesterday. And they said that they had taken a survey of everyone who was piloting grading contracts. I actually haven't piloted it yet, but their observation was that there were two subsets of students in the upper levels for whom the grading contract wasn't working as well. And they were pre-med and pre-law. And the reason is because the presumptive, the sort of baseline B grade, right, for doing all of the labor was to that population basically an F for
right.
A lot of them, right? And so so there was discussion about how that might get adjusted. So Lindsay, have you had that experience? Did you have that experience when you were teaching?
Yes. So I haven't done the grading contract at the law school level. I don't have the privilege of doing that at this stage. I did do it at the undergrad level, and I did it with the baseline B, and everybody did the extra labor to get to the A, right? So what ends up happening in a lot of cases is that you have this kind of skewed scale, right? Because if everybody in the class or the majority of the students in the class are willing to take on the extra labor and do the presentation, then you end up with all A's in the class, which, I mean, on one hand, if you're somebody like me who's just generally opposed to grading writing in the first place, then the problem lies elsewhere, right? The problem doesn't lie with the contract. It lies with the problem of grading writing in the first place. So can it be resolved? Maybe not, right? And I think especially as you move on to the law school level where grades are so important, I don't know that you can get by. I was actually talking with one of my colleagues today, and I said, I wonder if pass-failing legal writing would change our ability to not, have to meticulously put numbers on students' papers. But I don't know if that would solve the problem either. I think the undergraduate students, you can kind of get away with more A's based upon labor than I think you can at the law school level. And I think, Antonio, you actually hit a really important note in your presentation when you talk about that privilege of having the time between, you guys are not about to go out and become practicing attorneys right now. So I'm allowed to play a little bit with my structure and my course. And I'm definitely experiencing that now that I've transitioned to the law school after 8 years of being at the 7 years of being at the undergraduate level. Now in the law school, I'm realizing there's all this pressure to make them practicing attorneys. When you leave my class, it may be the only time that you have ever written a motion for summary judgment. And so the pressure to make them successful practicing attorneys is definitely there on a different level for me.
Yeah, you both are touching on something that I think is really interesting about teaching legal writing to undergrads, which is this really strong connection between what we teach and then what's going to happen at law school. And you all have touched also in your presentations on a sort of underlying disconnect between the ways that legal reasoning and writing are taught or even conceived and the actual reasoning and writing that goes on in the actual practice of law. So I'm wondering if all three of you, if you have any thoughts about what is the most important skill or technique or concept that the undergrad legal writing course should focus on or can focus on realistically?
I'll start. So one thing that occurred to me when I was watching Brian's wonderful presentation was, right now I just finished grading a set of papers, and it was the students' first memos, and they all have the same memo assignment. And one thing that's really hard for them to wrap their heads around is that when I give them a prompt, that there isn't just like one right answer, right? What struck me in Brian's presentation when he was talking about that there are multiple, tools that we use to reason through the law. It struck me that for a lot of undergrad students, the idea that two students can arrive at directly opposing conclusions on the same objective legal query is just bizarre to them, right? And if in fact, the practice of law and reasoning was this deterministic imaginary that's posited by you, Brian, that would be impossible, right? If it really could be reduced to math, that's just not how math works, right? And so one of the first things I have to convey to them so that they aren't anxious is that when their ultimate conclusions are wildly different than their classmates, that it can still be equally successful in terms of what their finished product is. And so that's just sort of, I think, the first thing that I have to sort of convey to them. And the way that I often do it, I hearken back to my days in practice. And I remember when I was a junior associate and partners asked for my conclusions of law on things. And I remember figuring out pretty early on that my ultimate conclusions were not that important to them. What was important to them was the reasoning, what got them there, because the reasoning revealed to them tools that they could use. It's not like they were just going to adopt my conclusions. They wanted to see the work, right? The way that I was piecing these things together and making those and because those were the things that they would piece together, that would make their way into a finished brief. And so I think that's one of the important things to convey is that we're not. It's not about arriving at the right answer. It's about arriving at a logical process and figuring out all the tools available to you.
Yeah, I would actually agree with that. I think a lot of my students are surprised that the law is not black and white, that there isn't a right answer. When they'll come to me and say, well, what's the answer? And if there is one answer, then you don't have a job, right? So why are you expecting there to be just one right answer? So I think maybe the skill is that, right? Is the ability to see the multiple perspectives or outcomes and reason your way through it, I think is something that students I see lacking definitely at the 1L level. And they really do want, they have this surprise. They want there to be a right or wrong answer. And when I'm saying, no, just don't, don't tell me there's a right answer. Tell me what the possible likely outcomes could be in this case, or reason your way through it. They really struggle with that. And in fact, they also struggle with that in their other law school classes as well. I notice when they're doing their exams, their written exams in their other classes, they're having the same problem. It's not memorizing the law or the rule, it's the analysis that they struggle with the most, it seems like.
Yeah, I think I would echo both of you. The term that I'm using, and I'm using it because it's unusual outside the law, but I think it's useful here, is that every legal argument is defeasible. It doesn't matter who's making it. The US Supreme Court makes a legal argument about some conclusion, we can have a constitutional amendment that overturns that, right? And these arguments continue from case to case. So every legal argument is defeasible. And I think that's principle number one. So whenever they see a rule, you have to teach them to look behind the rule or look around the rule and see whether there's going to be an exception, whether there's a supervening principle that might trump that rule. Sorry to use that dirty word, or something along those lines. So that's one principle that's important. The other principle, I think, in the law, and this helps to address some of what I think Antonio talks about in his presentation. In the law, the audience and the audiences correspond to genres, or genres correspond to audiences. I think in Swales's terms, a genre is a property of a community. And property has two meanings, right? It can mean it's a characteristic of a community, or it can mean something that belongs to a community. So when we're teaching students the genres that they're writing in, they like to see examples. They really love to see the example. And that's okay, it's good, as long as we can talk through with them why the example has the characteristics that it has, and why the audience might care about those characteristics being what they are, so that when we introduce them to a new kind of genre. So I had my students just finished writing a bench memo, which is the brief that a clerk for a judge would write to the judge, telling the judge what both sides' arguments are and suggesting the judge how they might rule on the case. And there aren't a lot of good examples of bench memos out there in the world. So I said, make it up. And they struggled terribly because they didn't understand, because they didn't have something to look at. And what I asked them to do is, well, think about what your judge needs to do. Think about what it is she has, and think about what it is she wants her next steps to be, and how could you provide her the tools to make those steps. It didn't work very well because they don't like to think that way. But I want to keep reinforcing that kind of idea, because as soon as you associate genres with audiences, the genre stops being like this iconic thing that you can't meddle with. It starts being something that if you look at the audience and you see an opportunity to adjust the genre to be more effective with the audience, you have a license to do that. And it's sort of unreifies the genres in a sense.
Mm-hmm. Ryan, you lead me into my next question concerning audience. In the real world, in the practice of law, and even in law school, students and lawyers in the real world would be writing for different audiences. So you said different judges, different attorneys in their firm, opposing counsel, whatever it might be. And so I'm wondering if the lack of uniformity in grading, in other words, if this sort of subjectivity of grading at the undergrad level is not necessarily a bad thing, because it reflects the different audience preferences and needs and expectations that people will be writing to dealing with in the real world. Does that make sense? So in the real world, we write for different people. They are different audiences, and we hopefully know some of their preferences, or we estimate what their needs and expectations are as audience members. And so I'm wondering if some of that might actually be useful in bringing our own subjective preferences, needs, expectations as teachers of undergraduate legal writing to what we assess in the classroom. What do you think about that?
Well, from my perspective, I do try from the very beginning of, like, when I teach first semester law students, I do try to tell them that legal writers and readers have a wide variety of preferences that are genre-based. So those are things that they're familiar with, and they expect to see things that look like them. But there are also a lot of idiosyncratic pedantries in the law, right? I mean, don't end a sentence with a preposition. As Churchill said, that's something up with which I will not put.
Exactly.
And so, I mean, there are these pedantic things where people will insist you must do something some way or can't do something some way. And what I tell the students is you don't have to learn the right way to do it. For me, what you have to learn is how to switch the way you're doing it. Because if you have a supervisor who likes it one way and another supervisor who likes it the other way, you got to write it both ways, depending on who you're writing for. You don't get to choose that. The same if you know there's a judge that hates something or likes something. And so again, if you associate even things like grammatical details, contractions is a good example. I mean, plenty of good briefs these days are being filed in federal courts that use contractions, but the received wisdom is don't use contractions in formal legal writing. Well, that seems to me to be bogus. But if you know the judge hates contractions, you sure as heck are not going to use them.
Okay.
Yeah, and I think grounding it in rhetoric, right? I think if you ground your instruction in rhetoric, then you're able to be a better teacher regardless of what that audience is. So I think if you start at that base and say, hey, let's talk about rhetoric and let's talk about audience and let's talk about purpose, then I think you give them the ability to do that sort of code switching, right? And you're not privileging one thing over the other. You're telling them, this audience may privilege one thing over the other, and you now have the tools to make those changes. But if you come in and you say, this is the only one right way to do it, you're doing all of the students a disservice because they're not aware of what their clients expect or what, the interaction with the opposing counsel may not be so formal, right? You may be having a conversation outside of the courtroom that it needs to necessarily be different from the sort of formal writing that you would do for a judge. If you can ground your conversation in rhetoric first, I think you'll have a more successful legal writing class.
Yeah, I just finished doing a legal writing workshop on the student's first memo. And I have a student a business student who was giving his critique of another student's writing. And the thing that he was commenting on was the formality of the writing. And I think it was contractions actually that he was talking about. Contractions and then something with regard to punctuation. Oh, also first person, use of first person too. And he'd been trained in his business classes to that there was a certain type of writing, and that's what he associated also with legal writing. They were sort of close cousins. And so rather than taking a side necessarily, I mean, I made pretty clear that I don't necessarily share those beliefs, and whenever I'm evaluating writing, but I acknowledged that there were plenty of lawyers that I know and plenty of lawyers that I have worked for who would have those conventions and would have those preferences, and judges too. So I used it as an opportunity to talk about audience and to talk about how you will have to make those adjustments. I think that's right. That we have to be cognizant of that. Students have to be cognizant of that. And as much as they want to come out of this process with like the right answer in the right way, I think it's more important for them to be rhetorically flexible. Coming out of my class and out of your classes as well, probably.
Yeah.
Yeah. And I think for the bar exam too is something to consider. So eventually they're going to have to write for the bar exam. And if the bar examiners cannot understand your prose, then it's a problem, right? So we can say, oh, it's all labor-based and, there's no grading here and there's no standard here, but there is going to be a standard and it's going to shift, right? And so you can be flexible, as you say, and shift. But if one of the ultimate goals of getting a student out of law school and being successful is to pass the bar exam, then you do have to make sure that they have some of these grammar and basic foundational techniques, for lack of a better term, in place. So it's a tricky space to be, for sure. Mm-hmm. Again, I think rhetoric helps you get around it.
Well, actually, you all are doing such good segues into my questions. So the next one I was wondering about is sort of the audiences for your own classes. Are your classes composed mostly of students who, at the undergrad level, who think of themselves, I know, Brian, you're teaching at law school now, and Lindsay, so are you as well, but back when you were teaching undergrads, were they mostly students who saw themselves as pre-law, or were they students who were just interested in law, or students who just had to complete a writing requirement and your class fit their time schedule? Sort of what was your audience, mostly?
So for me, it was a mix of those three things you just mentioned. The undergrad courses I talked that were writing were called, the title of the course was Writing the Law of Science and Technology. So the students who came to it were usually either interested in the law of science and technology, needed the rigorous writing requirement, which that particular class satisfied, or were thinking of going to law school, or some combination of the three. And of course, there's always the one or two students who need a schedule filler. And I don't feel ever hurt that the student acknowledges that openly to me. That actually is helpful information as a teacher. But generally speaking, I saw a mix of those three things.
Antonio?
Yeah, I did as well. I would say about 2/3 of my students would identify as pre-law, right? That they're on their way to law school. And then 1/3 are there because they view the class as having some utility toward their future career, or they're just really interested in the subject matter. And even though the pre-law students have a natural investment, obviously, in the material, when someone self-selects into this, like they know that there are probably easier ways of fulfilling their requirement, but they're doing this out of interest. Like, those students are really fascinating too, and they often bring to the class different styles of writing, that help inform and excite and surprise me and the class. So I'm always really interested when someone comes in and they're like, I'm an acting major, and it's not by accident. I took it on purpose, and they just enjoy playing in the space or learning how to do this. But we inevitably learn a little bit more from those students than the ones who've just been thinking toward law school and have been working toward that LSAT the whole time. So it's often a breath of fresh air when I get those students.
Yeah, when I was at the undergraduate level, I was teaching, I would say 3/4 of the students in my class were pre-law. My class was a requirement for the pre-law certificate. It was the only legal writing class taught. So, the majority of them were pre-law certificate, pre-law students that were going in. I will say I had a handful each semester that maybe had me in professional technical writing or in first year writing, and they thought, oh, I like her, she's fun, or, I expect that this will be interesting class. But I would say for me, the majority of them were, pre-law, I'm going to law school, I have to get an A. You cannot give me something lower than an A in this class. That kind of approach for those students. And I would say that the challenge, I think, for some of them was that they would take the class and realize maybe they don't like this kind of work. They would say, oh gosh, I don't like reading really long cases and having to write about them. And I'd say, well, it's good you took my class. Maybe you'll reconsider, right? Not that I ever push students away from law school necessarily, but I never push students into law school either at the undergraduate level. I think that that's needs to be a well thought out choice.
Mm-hmm. Lindsay, you just mentioned something about challenges for students, and I'm wondering what the challenges are for you all as teachers. How, with your undergrad class, how do you design a course that is for pre-law students, that is intended to help prepare them for the work they'll do in law school, but that also is interesting and accessible to these other students who don't plan to go to law school, but have these other various reasons for finding themselves in your classroom? That's a challenge as a teacher. How do you manage those two different audiences?
I think when I designed the classes, I assumed everyone was going to be pre-law. So I just designed a class for someone who was preparing to go to law school. So what I found was that I didn't have to do anything. When students were coming in because they were interested in the subject matter, I didn't have to do much additional work to get them interested. They knew what they were getting into, right? And I make pretty clear on the first day of class, I'm a very intense first day of class person because I want people to know sort of what this is and what it's not. And you can tell, and students can tell, this is for me, this is not for me. And I really haven't, I even when I made the realization that I was teaching a number of students who are not going to go on to law school, I still kept getting a consistent, that consistent proportion who were still who just wanted to do it. So I haven't had to do, I don't think I had to do much additional stuff to cater to them.
Yeah, I am not a rigorous ever professor. I have a general kind of playful personality in the classroom, which can, it poses its own challenges. But I always first day of the semester say it at undergrad, we're just sticking our toe in the water here. I'm not trying to teach you everything there is to know about the law, and I don't expect that you are enrolled in other courses right now that are all about the law, right? At the law school level, you have this privilege of everybody's thinking and talking about the law all day long. Sometimes it's a pain because they come in and they say, well, I learned in contract law this other thing. Then you're thinking, no, take contracts out of my class and we'll just focus on this one problem. But you do have a little bit of a leg up at the law school level because they're all already thinking only law all day long. And so to the undergrads, I would say to them right off the bat, guys, I know you're not thinking about law all day long. I know you may have never read a Supreme Court case before, and I'm not here. I actually will say to them, or on the first day of class, I'm not here to give you your first C in undergrad. I'm not in the business of failing pre-law students. That's something that I would say to them. So I had a very different approach from the start, because I think maybe it's because I do come to writing from a place of compassion generally. So my approach is very playful and very compassionate, and my feedback is always caring, right? Those are the words that I get in my student feedback forms. So I think to me, it really was more of we're just playing in the sand here. You guys can try to build the castle, but you don't have to create this, magnificent piece of legal writing by the end of the semester in order to be successful in this class. Now, I also, if you noticed in my presentation, see that a lot of students feel like they are coming into law school unprepared. So maybe it needs to be a little bit more rigorous than playing in the sand. I'm not sure.
Yeah, I'll answer the question, and then I'm gonna push back on that last idea because I wasn't at all worried about law school readiness when I taught the courses I taught at the undergraduate level. The courses were designed as rhetoric or technical communication courses. They were really designed to get students to think about how the law is embodied in these texts and how the texts constitute the law. And so there was writing, and they had to I must maybe say mimic legal writing, but they were doing it in a way that required them to be conscious of what the rhetorical choices were that they were making and what they thought the rhetorical choices of the legal writers were that they were making. So I wasn't as worried about that. I mean, honestly, I wasn't trying to integrate. I didn't care whether they were pre-law or not, because I didn't think I could prepare them for law school. And that's the point I do want to make. I don't think it's very easy to prepare undergrads for law school, because the shock of getting into the first semester of law school when all you're thinking about all day is legal stuff, that's just something that's very difficult to prepare for. And the cognitive science would back me up on things like, for instance, if we take pains to make them work really hard on their writing mechanics, things like grammar and punctuation and stuff, when they get into law school and they're learning new ways of reasoning about and organizing problems, to focus all their cognitive energy on those new things that they need to learn, they're not going to remember all the mechanical stuff. That requires a lot of cognitive energy. And one of the reasons in my first semester legal writing class at the law school, the first assignment that I give, the major assignment out of 3 for the semester, I tell them, look, I'm not going to mark your I'm not going to grade your mechanical errors on this assignment. I'm going to mark every one of them though. And I'm going to mark them with an eye that someone like me as your reader would if they were your real reader. And then as the semester goes on, I tell them I'm going to start ramping up the attention that you have to give to mechanics. But first, I want you to learn how to reason and organize your thinking. And then let's go back to worrying about, whether you put a semicolon here or a colon or a comma or whatever. So I think that preparation thing, and this is, if you read the literature from 100 years ago, and I know Lindsay's familiar with some of this, at Harvard University, the writing teachers are talking about how the students are not prepared to write when they get here. And then at Harvard Law School, the professors are saying, our students don't know how to write when they get here. Well, of course they don't know how to write in the legal genre when they get to law school. They came there to learn that, right? And so if you're not prepared to meet them where they are and get them where they need to be, you're in the wrong line of work. And Lindsay, I don't mean to suggest you were expecting that from the students or anything like that. But what I'm saying is, I think for us to be too hung up on that is to miss the point that they're on a journey. And when they get to law school, if they're prepared for legal writing, then they probably are already a lawyer somewhere in some other part of the world. Well, maybe not, because there's a lot of different styles of writing around the world. Or maybe they were a paralegal for 5 or 6 years and did a lot of writing for another lawyer, but that's a really rare case.
Follow up on that. I'm wondering what you all see, if you see any big change coming to the way that legal writing is taught to undergrads. If you don't see any big change coming up on the horizon, is there like one big fundamental change that you wish you could make happen? What would be your big wish to teach legal writing to undergrads differently? If you could do anything you wanted. You don't have to worry about how many weeks the semester is. You don't have to worry about grades. Do anything you wanted. What would it be?
Well, so I teach a general education requirement, right? So the USC has 2 composition classes, a freshman level and advanced level. And so I'm obligated to teach my course in the same sort of style and the same sort of arc with the same number of assignments as someone who is teaching an academic essay, teaching in the academic essay or other types of, normally academic essays. And the issue that I found was that when it just takes time for students to really understand how to read a case and how to negotiate these sort of new structures. Whereas if you're teaching an advanced course in academic writing, well, academic writing is what they've been doing, right? So, it's a sort of weird thing where my class is called an advanced class, but it's still an introduction, right? So, the normal arc of a semester at USC in advanced writing is there's a 4-paper sequence, and that's what you need to do. But what I found, basically, I've just sort of finessed those 4 papers, right? Because there's no way I'm going to teach them, like I'm going to have them write 4, substantial legal papers in the course of a term. That's crazy. And they're just going to do a bad job on all of them. So I guess my solution is the thing that I've actually already done, which is just, assign fewer papers so that we can have the time to really dive into the structures and why we're doing the things that we're doing. Because I feel like I'm still moving quickly, and students certainly feel like we're moving quickly. But at the end of the day, I turned one of the papers into like their personal statement for law school, because that's a thing that they want me to read anyway. But it doesn't require, me to teach them, new like structures and new ways of reasoning. But for me, the sweet spot in an introduction to legal writing class is just as I teach, we do 2 papers, we do 2 memos. So they're introduced to it first, and then and then after they get the feedback in that first workshop, they get to do another one, which is a more complicated assignment, but which they will inevitably do a little bit better on because they're just more familiar with the genre. But we just have the time to really dive into the assignments and for them to really for them to feel relaxed. And because my first years teaching this, when I was trying to fit in all all the assignments in a short period of time, it was just too much. So that's what I've done in my classes over the years.
I think that if I had my own imaginary world, I would strip grading, first of all, out of the undergraduate legal writing class. There would be no grades, but I would still provide feedback. It's as Brian mentioned, giving the feedback up front, but not weighing those things so heavily. If you could really do that all the way through, and I think it also builds off of what you're saying, Antonio, with that sort of reciprocal process of writing. If I can take one piece of writing and kind of workshop it all the way through the semester without focusing on grades, that would be my ideal writing class for sure.
So I'm going to build on that too. I think I agree with what Lindsay just said. And I mean, I don't know if we can get rid of the grade, but I just like the idea of disassociating feedback and workshopping, the subject of Antonio's presentation, disassociating feedback and workshopping from grades. I love giving students feedback. I hate giving grades because I always feel like I'm just drawing a line somewhere, and I don't feel all that confident about the line. In the law school, I don't have any choice. I mean, the average GPA of the grades that I give a section of my class is 3.4, which isn't bad, right? I mean, it means everyone can get a B plus, or someone can get an A, but then somebody has to get a B. And so, I mean, or I guess a B minus. So, I mean, that's a struggle to me. Giving the feedback, I mean, I could just do that for days. And part of the problem, I think, the way that people react to labor-based grading is they perceive it as the instructor trying to get out of the feedback part of it, because they associate feedback and grading. But if labor-based grading, lets go of the grading part when it comes to the feedback that you're giving, then you're not just justifying a grade, you're actually trying to help the student understand what it is that they've done from the perspective of you as a reader. And that seems to me like it's brilliantly valuable. So I guess I would join with Lindsay on that. I mean, my own focus would be different, right? If I were teaching an undergraduate legal writing course right now, I would be hammering home the defeasibility issue and the genres issue, the genre/audience relationship issue, because to me, it's critical someone going to law school not to have that shock in the first week where they realize none of these rules ever gets applied as written, basically. Or if they were, nobody's ever going to call me to help with that, because that's not the kind of problem that lawyers solve.
Yeah,
I would say just absolutely the first thing people say to me when I talk about labor-based grading is that I don't want to grade papers. And that's not true at all. I actually will sit down and talk with students and I will give plenty of feedback on their papers. The problem is if they see all of this feedback, they shut it off because it means bad grade to them. And I don't want my feedback to mean bad grade to my students. I want it to be, we're learning, we're growing, we're thinking through this process.
Yeah. Oh, is your hand up, Brian? Oh, okay.
I was just clapping.
Oh, okay. I share your fantasy of y'all of not having to do actual grading. I would love to have my class just be pass, no pass. And like Antonio, I would love to have more time. I teach on the quarter system, so my class is just 10 weeks long, and I squeeze in 2 memos so that the first one is sort of practice for the second one. And I would love if we could just have more time to read cases and talk about them. That leads into also some of Brian's concerns. It's a sort of a shock for students to realize how malleable law is. Each of us could read a case and formulate a slightly different rule for what that case stands for. And they're all reasonable, they're all grounded in the case itself. I also would love to be able to get students, give them the time to develop their sensitivity to and awareness of the importance of facts in the law and the details of facts and the nuances of facts, because that's what cases really turn on. They're really all about the facts. And that's something that students coming into undergraduate legal writing usually aren't aware of at all. Well, those are all the questions I had. Does anyone have any follow-up questions or any comments you want to make about what we've all discussed, or our fantasy undergrad legal writing classes would be like, or how we can make that happen?
Well, Lindsay had some questions at the end of her presentation that I thought about some answers to. And so I might want to just talk about one of those because she talks about the benefits of labor-based grading, and in particular in relation to the undergraduate legal writing course. And something that we struggle with, Lindsay and I probably both struggle with, is that we can't give everyone an A in our classes. But what I have found is that I can do a lot of labor-based grading and then have the number of so I have a large number of assignments, or I call them exercises because assignment sounds so grand, exercises every semester that students just need to do, and they get completion points. And I warn them at the beginning of the semester, I say, look, usually 60% of my students get 100% on that part of the grade. And if they do, it's very hard for them to get lower than a B- for the class. So it's not contract grading quite, right? But if you want an A in the class, you almost certainly need to do all those things. And if you do all those things, you almost certainly aren't getting below a B-. And that creates a much more sort of narrow range. And then the graded assignments, they don't like alter their world in the same way. And you think that pre-law students are grade focused. Well, wait till you meet law students. I mean, they're super grade focused. And it's not their fault. I mean, they're made to be that way by the law school culture and the employment culture. And so I think there's an opportunity there and so the workshopping activities that we do in my classes, which are different than Antonio's, and I've learned some things from him that I want to try. But the workshopping activities I do, so much of that stuff is completion points. You submit a draft, you get completion points. You respond to the draft in a certain way, you get completion points. And the students kind of don't like it at first because it means they're delivering something 2 or 3 times a week for me during a 12-week semester. But by the end, they're grateful because they see how their peers approach problems from a different rhetorical perspectives. We project their work on the projector in the class, and we talk about their writing in front of other students. And Antonio, one of the things I loved about your approach is that many of my students will say to me at the end of the semester, nobody has ever talked about my writing in front of anyone before. And that made me so much more interested in my own writing, to think that people were going to be talking about it. And I was afraid, but I was also motivated and excited about it. And the other neat thing you can do is if you can use a tool, I use Eli Review, it's a peer review tool. If you can use that tool where students give each other anonymous peer reviews through the tool, because it assigns them and does it anonymously. And then when you workshop, one of the opportunities I've had is to select writing. Normally in a semester, all my students' writing will end up on the screen at some point or other. But often I'll select early from students who are from marginalized backgrounds, but who have done good work. And really to start creating a kind of rhetorical ethos for those students in the class right at the beginning of the semester, and break down some of the expectations they have about themselves, maybe, or the fears they have about themselves, and some of the sort of more smug expectations other students might have by themselves, by showing that they're all, they all have strengths and weaknesses. And that seems to me to work. So I think I don't remember what the question was, but oh yes, it was Lindsay's question. So I think the labor-based grading stuff, getting them motivated to do these things because it gives them points and they need points to get a decent grade, is a good way to get them going. And once you get them going, it's not that hard to keep them going, at least in my experience.
For the peer critiques that I have students write, because students will end up writing 18 one-page critiques of like their peer work over the course of the term. I grade that on a completion basis. I mean, to do it any other way, honestly, would be bizarre, because you're going to judge someone's judgment of a completely new genre, and right. So, as long as they put forth the effort to write something, I'm not going to tell you that your critique of it is wrong, right? So they just got full credit. And yeah, that actually, so, I said personal statement, 2 memos. How do I get to 4? That's the 4th component, right? And so that's a percentage of the grade that they just get like the full credit for, as long as they do it. So yeah, I'm integrating these principles, Lindsay, into my classes in a limited way. And I do find them, I find it necessary for fulfilling sort of the requirements of my department, but also it's useful to give students a little bit of a buffer and peace of mind in that whatever they're doing, whatever grades they're getting on the memos, that's balanced with all of these other things that are participation based and labor based.
Yeah, and I think that I incorporate some of those things in as well, like reflection writing. How do you grade reflection writing? So you did a reflection and now you've thought through this. Congratulations, you've got the pass grade on it. The structure that I have right now in my program is that we all have the same syllabus and we all have the same grading parameters, right? So we have the same assignments and they're worth the same amount of points. I'm allotted a certain amount of professor's exercises that I'm allowed to work with. But one of the things that I've done this semester is that I've taken, so if let's say the assignment is an e-memo and it's worth 10 points, right? Well, I'll say, draft me an email that's reflective of how you think you could have done better on another assignment. And that way I'm getting the format of the email assignment out of the way. But that is a pass-fail component of my 10 points, right? So it gives me the opportunity to, do an initial piece of writing that I can workshop and give them feedback on, so that I'm not ticking off points for, no greeting in your email, right? That you're going to later submit to me as an e-memo. But it does allow me to kind of buffer that assignment a little bit so much, so I'm not sitting there redlining everything and then calculating later, well, how many red lines is this? And then how many points does that really mean, right?
Well, thank you, everyone. I think we've probably reached the conclusion of our presentation. Yay. It's nice seeing you all, and nice to have an audience out there. I hope we have an audience for this presentation.
We'll see what we can do about that.
Yeah.
Thanks so much, Lisa. Thank you guys so much. It's good to see you.
Good to see you all.